Well, welcome to those watching and thank you for your time. Today is the third snapshot that is being hosted by Primerio on African jurisdictions covering inter alia competition law developments. The speakers for today's snapshot will be Andreas, Stargard, Tyla, Coertzen, and myself, and we are from Primerio Law Incorporated, as well as Dr. Willard Mwemba from the COMESA Competition Commission, which for ease of reference we'll just refer to as the Commission or the CCC interchangeably. By way of brief background of Primerio, we are a Pan-African law firm with our head office in Johannesburg, South Africa, and a regional office in Kenya as well as in Mauritius. We also have strategic partners in several other key African jurisdictions. Our primary focus is competition law, including cartel investigations, merger control, abuse of dominance complaints, foreign direct investment, market inquiries, and the like. While it's not specifically relevant for purposes of today's snapshot, Primerio also offers white-collar crime, general commercial, trade, and regulatory legal services. Moving on to our esteemed guest, Dr. Mwemba was appointed as the Director and CEO of the Commission on 9 November 2021, having been with the Commission since January 2013 and serving as the Commission's first ever head of the Mergers and Acquisitions Department. During his tenure at the Commission, Dr. Mwemba has been instrumental in the enforcement of consumer and competition legislation at a national and a regional level as well. In addition, he's assisted several national competition agencies in developing and implementing their merger and restrictive practices divisions, and on a regional level, he's been instrumental in reforming the Commission's legislative regime. Of course, it's a great honor to have Dr. Mwemba here with us today, so I thank you for sharing your time and your knowledge with us.
As the regional agency, thank you so much.
Thank you so much, Dr. Mwemba. So as the regional agency representing 21 African states with over 600 million people and the largest market for trade and investment, which recently reported a 15% increase in its global trade, the Commission is one of the most important agencies on the African continent. While it commenced its authority initially in respect of mergers, the Commission has quickly developed into a force to be reckoned with in respect of prohibited practices as well. As a firm that frequently engages the Commission, we're delighted to be able to share with our audience today a brief background to the Commission's merger control regime, as well as some recent developments and what we can expect from the Commission in the near future. So briefly, the Commission has for several years been known as a highly active and competent authority, overseeing trade between its member states and promoting competition within the common market through monitoring and investigating anti-competitive practices with undertakings within the common market and then mediating such disputes. Its merger control regime is mandated by the COMESA Treaty and is outlined in the COMESA Competition Regulations and accompanying rules, guidelines, and practice notes. In accordance with Part 4 of the regulations, the Commission requires that parties to a proposed transaction notify the Commission when the transaction results in the direct or indirect acquisition or establishment of a controlling interest in another entity where both or either of the firms operate in two or more of the member states and a turnover or asset value threshold is exceeded. Earlier this year, the Commission released a revised practice note on the meaning of the word operate, which essentially provides that an undertaking is considered to operate in a member state if its operation in that member state is substantial enough for the merger to have an appreciable effect on trade between member states and restrict competition in the common market. Currently, the turnover and asset value threshold respectively is 50 million USD. Additionally, the Commission may require merging parties to notify a merger in instances where it appears that there will likely be a substantial prevention or lessening of competition or an outcome that is contrary to public interest as a result of the merger. Furthermore, transactions must be notified to the Commission in writing as soon as is practicable, but no later than 30 days after the party's decision to merge. In our experience, the Commission generally considers the signature date of the sale and purchase agreement, or an agreement with a similar effect, to be the date on which the parties have decided to merge. So to elaborate on this, the Commission consequently draws a clear distinction between parties' decision to merge and the implementation of a merger, and as such, a later date of implementation doesn't alter the fact that the parties signed a binding agreement on a different date. It is further useful to note that despite its strict interpretation concerning a decision to merge, the Commission does accept merger filing forms based on unsigned agreements, granted that the agreements are subsequently signed in a form that has not materially changed the transaction as soon as reasonably possible after the filing. Filings must be accompanied by a non-refundable fee of 0.01% of the merging parties' combined annual turnover or combined asset value derived in the common market, whichever is higher. Once a merger has been notified to the Commission, it will examine the merger within 120 days of receipt of the complete merger notification. However, it may inform parties before the expiry of the 120-day period, should it require a longer period. During its inquiry into the merger, the Commission applies a substantial lessening of competition test as well as a public interest analysis. The Commission will thereafter prohibit, approve, or make another appropriate order in respect of the merger. Failure to notify the Commission of a proposed transaction will result in a maximum penalty of 10% of either or both of the merging parties' annual turnover in the common market in the preceding financial year. I now turn to Tyla, who is going to provide us an outline of some of the recent developments in respect of the Commission's activities.
Thank you to Nicola for the introduction and to Dr. Member for joining us today. My first question relates to the AkzoNobel case. Recently, we noted that the Commission issued its first partial refusal in relation to the proposed acquisition by AkzoNobel of two Kansai Plascon entities, representing this Commission's first merger prohibition since its inception in 2013. Interestingly, this partial refusal follows an inquiry conducted by the Commission in 2021 in respect of anti-competitive conduct and horizontal practices among paint distributors, of which Kansai Plascon was referenced. The investigation concluded with the Commission releasing a cautionary note to the parties engaged in anti-competitive behaviour. In light of the Commission having assessed a total of about 400 mergers and about 40 restrictive business practices, it is clear that the Commission has thus far maintained a dominant focus on merger review. Dr. Mwemba, how do you envisage the Commission's enforcement activities developing in relation to both merger review and prohibitive practices investigations in the new year?
Thank you so much, Tyla, for that question. Thank you, Nicola, for the excellent introduction. I was thinking to myself here that probably my job is not safe. If she knows all that about the Commission, then I may easily be displaced. Yeah, because I think that is a very excellent synopsis of the operations of the Commissions and this major control regime. Tyla, your observation is correct. 400 mergers versus 40 restrictive business practice or conduct cases. So basically 10%, about 10% of the work that we have done in mergers. How I see the enforcement unfolding. The first thing I would say is I see the Commission continuing with the good works. I hope I'm not sounding my own trumpet, but the good works that it has done in major control so far. I think we've gained quite very good experiences in that field. And as you rightly observed, recently we did prohibit the merger involving AkzoNobel and Kansai. We've reached that stage because of the experience that we've gained over the years and because of the focus, as you said, that we've had in mergers. Previously, and Andreas has been part of this journey Primerio, basically. Previously, you will recall that even our decisions were a one page, in fact, one paragraph, then we went to one page, but they are quite detailed now. When we started, it was always unconditional approvals and conditional approvals. We reached a stage where our assessment was more thorough and started giving serious undertakings, both behavioral and structural. And in those cases where we're giving those undertakings, both behavioral and structural, frankly, it did mean that the Commission actually was on the trajectory of rejecting the merger or prohibiting the merger. If you look at some of those cases, if you go on our website, the comprehensive undertakings that we gave were almost as good as rejecting a merger. In some of them, I was even saying, I can't understand how people would still want to go ahead with all these conditions that the Commission has imposed. Uber Karim, I would urge you to read the Uber Karim case, which is on our website. if you look at the conditions that were given in that case, even myself here, who was involved in the drafting of those undertakings, I said if I were in their shoes, I would have rather said I'm not proceeding with this merger. So yes, we could have prohibited the merger in Kansai, Akzo now, but I think we've been on that path for some time now. I think in the Akzo Kansai, that would have been our approach, because usually we want to remedy the situation rather than an outright prohibition, because mergers also have got certain benefits that they bring to markets, right? So in the Kansai Akzo, I think we just reached a position where it was not possible whatsoever to salvage that transaction. So you can still see us now rejecting mergers. And when we see us rejecting mergers tomorrow, it shouldn't mean that that's when we started thinking about that. We've been thinking about that, except to the extent possible, salvage the case. We are reviewing our regulations and just to make sure that our major control system is much more certain and predictable than where we are now. You mentioned issues of the word operate. If you look at our law, those terms are very vague. We supplemented them in the guidelines and in the notices. Those are things that we are making very clear in the draft law that we have. And I'm glad that you'll be part of the team that would be making comments to that law, because internally we've finished our processes, so we'll be exposing it to stakeholder consultations, and indeed we'll share it with you. So that is about mergers, but as you rightly observed, what do we do about the 10% of the enforcement efforts that we see on the restrictive business practices? I would start by saying that you see, every competition authority, when it is born, when it is formed, there is a reason to believe that they may not be as exposed to the enforcement world as is expected. And I'm using these terms very carefully, because I don't want us to sound as if we were incompetent then. But it's a fact that we may not have been very exposed to the enforcement skills, if I may use that term, especially that we're dealing with different countries here, where it may be a bit easy if it's just at national level. And I know even at national level, I came from Zambia, where the commission was established in 1997. But by 2007, it had not done much. But later on, Zambia probably, their competition authority is one of the most established competition authorities in Africa. So it takes a bit of time, because you're still trying to find your feet. You're still trying to see what can work, especially that restrictive business practice investigations require a higher standard than mergers, require quite some skills, quite some law interpretation of the law that is thorough. So it took us a bit of time, not that we didn't know from the word go that there were anti-competitive conduct in COMESA. We knew, so it's not by design that we didn't do much. We knew, but I think we're trying to find our feet. I'm glad today to tell you that the 10% you referred to is what is in public domain. Currently, we have a number of cases, including cartel cases, that we are investigating. Some of them at an advanced stage, where in some of them parties are even willing to give us information in exchange for lesser fines and things like that. So going forward, I think I've spoken so much. Your question was very simple. Going forward, what do you expect? You expect to see much more enforcement from the COMESA Competition Commission than just mergers, because there's lots of appetite in that area. We have established ourselves. We have made sure our law is accepted by our national competition authorities and the member states generally. At the beginning in 2013 and a number of years later, one of the other issues was that, you see, because we had just started, probably member states were not so sure if we would investigate some of those cases thoroughly and bring them to an end, or with adequate remedies, that their countries or their territories do not suffer the effects of not having done a good job by the COMESA Competition Commission. Where we have reached now, that is settled. Some of the countries, in fact, even on the current cases that we have, we are working very closely with them. So I think that's what you expect to see from us in a nutshell. Was that a nutshell? But that's what you expect to see from us.
Thank you a lot. That's definitely very useful. And to your point about that exchange of information between parties in the Commission, it's certainly, like, the leniency regime is definitely an investigatory tool that is often used by enforcers worldwide, and it's proven to be one of the most useful investigatory tools for competition agencies. But I do imagine the challenge of investigating as a regional body is even more heightened as opposed to one competition commission within a country.
Yeah, so that leniency thing you raise, if I may just, sorry to interject, the leniency thing you raise, for example, is a very important aspect. For cartels, I think we've seen it working as a very effective tool. One problem we had is that in our law, there was no provision that gave us power to come up with a leniency policy. And we did attempt to come up with one. We have a draft that we did with the World Bank, but then we realized that it was just a guideline. And if I'm a company that is involved in a cartel, I would think twice to come to the Commission, because basically a guideline is not binding. So I may expose myself, and then at the end of the day, I just become a subject of penalties, even in the country, in countries where I operate. One of the things that we have done currently in the amendment is that we've made it a very express that we will have the power to come up with a leniency policy. And once there's a leniency application at the COMESA Competition Commission, those who come and successfully file for that leniency will not be exposed to any further action whatsoever by authorities in their member states. So that is a very good tool, because if I'm a company that is an offender, I know that I'm not just exposing myself going to COMESA, and countries use that evidence to prosecute me at national level. So we hope that also we will trigger more cases in the cartel realm coming to the COMESA Competition Commission.
Yeah, agreed. That will definitely be useful. I'm going to move quickly on to my second question so that we've got enough time for everybody else. Earlier, Nicola spoke about the 30-day time period within which merging parties have to notify their transactions to the Commission, failing which they might have hefty fines imposed on them. In this regard, we've been privy to some transactions where parties haven't been able to meet this deadline, and as a result of confusion, that comes as a result of confusion of when the decision to merge takes place. So without getting into more of the interpretational issues of the regulations, we have seen the Commission's revised guidance note, which allows for merging parties to engage with the Commission when they're uncertain about when they've entered into a decision to merge within that 30-day time period without having to completely notify the transaction. We've also understood from the Commission's 10-year anniversary that it is expected that the Commission's merger review regime is likely to change from a non-suspensory to a suspensory regime. What impact will this have on the 30-day notification rule?
Thank you for that question. And frankly, and I hope I can be as honest as possible at this forum, the 30-day rule, in as far as I was concerned, was a very bad law. And that's why when you say you understand that there's been frames that actually did not meet that 30-day period, and they were not fined. It's unfortunate if they are there. We did find at least 2 of them that blatantly disregarded that 30-day rule, and they were only fined because law is law, even if it's a bad law until it is amended. But if you had to ask me and I were to give you an answer from deep down my heart, I would tell you that to me, I've always said that was a bad law. I didn't serve any proper practical essence. It just brought more confusion. So what we have done in the draft, the amendment that I've spoken about, that one has been removed completely. And then we've introduced an express suspensory regime. So where there's an express suspensory regime, the trigger of the 30-day is virtually irrelevant. It is ineffective. So to answer your question, the impact that this would bring is that, number one, it would reduce or completely eliminate actually the confusion in determining at what point has the decision to merge been made. I heard initially you had said the Commission has always looked at this the sales and purchase agreement or other agreements of similar effect, true. But even now, we've had situations even where there's a clear SPA, especially for those that involve publicly listed companies. Where does the decision to merge, what is the trigger? Because our guidelines are saying at the announcement of that public bid. So there have been a number of issues, and as you said, we'll not get into interpretation now because of time, but there have been a number of issues still, even after trying to clarify that it will be an SPA or something of similar effect. So the suspensory regime will virtually eliminate that problem, both for the Commission and indeed for the parties who would have less burden, because it will be very clear that they can do whatever they want. They can sign an SPA. They can whatever would amount to a decision to merge. But as long as they've not implemented that transaction without the notification to the Commission, then they are very safe. Currently, the lots of uncertainty, I think, gives a lot of burden on the parties. And if I were to borrow your words that you've seen some who've not actually complied with that, the more uncertain the law is, the more you expect, the more non-compliance you expect from that. So yeah, that would be the effect. Basically, the 30-day period will be relevant, more certainty to both the Commission and the parties. Yeah.
Thank you, Willard.
Thanks, Dr. Mwemba. I think that goes quite well to your comment earlier of us being able to take your job, and this is why we can't. It's because you can provide us with all these interpretational insights. So yeah, it's very, very useful information that we obviously weren't privy to, and it's good to know that even as an established agency, as we mentioned earlier, the Commission continues to identify what works and what doesn't work and make amendments on that basis. So yeah, I know, Andreas, you have engaged the Commission essentially since its inception 10 years ago, and you've continued to keep a close eye on the Commission's developments. So what are some preliminary questions or issues that come to mind for you in light of the Commission's expansion into the realm of non-merger enforcement?
Thank you, Nicola, and hi, Willard. Thank you for joining us. It is always a pleasure seeing you. And just the first, I don't know, 20 minutes that we've been speaking so far with you is again evidence of that in my eyes, and I'm sure in our listeners and viewers' eyes of this podcast. It is truly refreshing, and I mean this also from the bottom of my heart, to see the head of an agency, and I know many of your staff personally as well. They are all hewn from the same sort of rock as you are, and you have instilled, I believe, that same attitude in all of them. To see a head of an agency and his team truly listen to the business people who deal with the merger regime and other related legal instruments that you enforce, to listen to the international community. I know Randy Tritell is no longer at the FTC, but his successor, Molly Askin, meets with you frequently, I believe. Many other folks from other international including many African competition authorities, meet with you, and at this point have begun truly looking to the CCC as a guiding light and a shining star on the competition enforcement scene, if you will, and to actually take criticism and suggestions into account, weigh them, and acknowledge when a law is a bad law, change it when it requires changing, make the moves as swiftly as possible, which to me is actually really impressive, given that there are over 21 at this point member states, that you can get this done in such a short time period. So my compliments. To Nicola's point of the question, you've already answered several, actually, also regarding the member states and their now, I would say, acquiescence and agreement with the CCC regional regime. I would like to get a little bit into what lies ahead for the COMESA Competition Commission as a whole in the next 10 years or so. So let's broaden our time horizon for a second, and let's look at things such as the AFCFTA, the African Continental Free Trade Agreement, and other supranational, regional, perhaps even larger than COMESA regional bodies.
Yeah.
And I know that the CCC recently announced several other memoranda of understanding and potentially supra-regional cooperation. What do you see the role of the CCC within a larger African context as, and what are the challenges that you envision?
Thank you so much, Andreas. And I think I should take this opportunity also to thank basically Primerio and specifically Andreas for Nicola and Tyla. In case Andreas has not told you, he was a very fierce critic of the Commission's approaches to certain issues at our inception. And especially on the major regime, I recall I was the head of majors then, that at one point we had issued our one paragraph decision, and he was saying this is so strange that this is a regional authority and it can only give a one paragraph decision with some spelling mistake. So myself and my registrar, we quickly looked at that and indeed saw the spelling mistake and quickly withdrew the decision. But Andreas, with all his observations, all his recommendations on how things may be done better, are things that we took into account. So today, you are able to call us an established institution because not just because of us, but because of all those like Andreas and others who came and said, guys, we think you should do these things like this. They will improve your system. And from us, probably because we listened. And at the end of the day, we are where we are. So thank you so much for that. 2030, AFCFTA, changing dynamics in competition landscape, where do I see us? The first thing is I'm glad and very happy that even before all these things of AFCFTA and came in, our vision was very clear and it spoke to the exact year that you mentioned, 2030. It said we envisage to be a center of excellence in competition and consumer law regulation. So we start from there. And drawing from there, where I see us being in 2030 is that I want us to continue being relevant. And what do I mean continuing being relevant? There are so many changes there currently in this world from the legal perspective, political perspective, multi-crisis, and a number of those issues. And if we are to remain relevant, we should speak to all those things. How do we interact with all these issues of polycrisis that we are seeing? How do we interact with a number of other competition authorities here in Africa to make sure that our review of cases does not result in a suboptimal outcome, but an efficient outcome? And what are we doing to make sure that we achieve what I'm just saying? For remaining relevant, we have realized that we don't live in isolation. We are not an island. So we can only remain relevant if we are following scenes on the globe and what others are doing, those that are more established and more experienced than us. There's no need of pretending that there aren't those that are more experienced than you, because that's the reality of the world. If some people have been around for over 200 years, and we've only been around for 10 years, it's expected that they have more experience in some of these issues. So, for example, we have now forged relationships with the US FTC. You mentioned Tritel and Molly, but also the US DOJ, the European Commission. And why are we doing that? Is to try to make sure that we interact with them and advance or progress together as new issues are arising so that we remain relevant. For example, now we are talking about digital issues, we are talking about environmental issues. These are very, very new things to us, but also to them. But because of the long established experience that they have in competition law matters, it becomes very easy for them to navigate around those issues. And as they do that, if we are together, it also helps us to grow at the same time. So that is what we will do. Then secondly, in back home here in Africa, we want to remain the leaders to make sure that no gaps remain. Africa is bigger than COMESA, and that's why probably we're talking about the Africa Continental Free Trade Area. But the creation of the AFCFTA in itself does not resolve the problems that are intended to be resolved. There'll be need for systems there. There'll be need for structures. There'll be need for cooperation. There'll be need for coordination. And we think within this period, COMESA back home here with all the networks it has forged can do a better job to guide that system on how these regional economic blocks, including the AFCFTA, can work for an optimal outcome. And we are already doing that. I'll give you an example that already we have a meeting with the AFCFTA and member states of COMESA in Nairobi just after next week to see how we will fill in that gap without creating confusion to those that we are supposed to regulate. So we'll be having that meeting next week. And then at regional economic community level, the COMESA Competition Commission has already shown leadership for the very first time, very first time. It had never happened before. That REX in Africa, in any aspect of operation, whether it is trade, whether it is intellectual property, whatever. It had never happened that a meeting was convened where all of them sat and had discussion. The CCC showed leadership and for the first time brought all these RECs to discuss on how we are going to move forward without bringing confusion to those that we are regulating and without making it difficult and very expensive for those that we are regulating to comply with. But also, in doing all these things that I've said we envisage to achieve by 2030, we've also gone beyond not just the US, DOJ, FTC, EU, but other similar organizations with similar experiences like us. For example, the Caribbean Competition Commission, the Eurasia Economic Commission, the Competition Commission of South Africa, United Nations Economic Commission for Western Asia. We've forged relationships with all those that we are not just dealing with those that are probably much more established with whom sometimes situations may not be the same, but we're also dealing with those whose situations are very similar to us so that we see how we can address some of those issues that are challenging in real time, that are complex and slightly different from what happens in Europe and the United States. So Andreas, that is what I envisage to say in 2030. And by that time, we'll be inviting you for the 20th anniversary. So I hope I can come and attest to these things that I've said today, that they were delivered and they were achieved.
I can't wait. Although by then we will have even more gray or less overall hair. Thank you. If I may just follow up on one particular point that you made at the very end, because I find it fascinating. The meeting you referenced that you said showed the CCC's leadership in this area, which is an entirely novel concept, really, and has not been done by either the US or the EU or any of the other bodies that you referenced previously, which is the meta regional integration, i.e., you know, the meeting of multiple bodies that are similar to the CCC. The RECs, the various RECs coming together, being invited by the Commission, by you, and being brought together in one place to discuss the future of the peaceful cohabitation, so to speak, of these RECs. How do you see disputes that may arise, that surely at some point will arise, just like they arose when the CCC was created, right, regarding its mandate vis-a-vis its puzzle pieces, which were the member states of COMESA? How do you see at that larger level, at this sort of meta regional level, how do you see disputes being resolved? Will it be by dominance, without intending an antitrust pun here, or will it be by consensus? There is no further larger body that can regulate it, unless you're talking about the AFCFTA or the African Union or any body like that. How do you see disputes being resolved there?
That is a very excellent question, Andreas. Very excellent question. And the answer to that may not be very straightforward. I may give suggestions and opinions that I also gave to my colleagues from the other RECs when we met. The first thing is that we should be very honest and frank with ourselves, that we are not in this business for ourselves. We are in this business for the market and the business community. So sometimes I even at the beginning of the COMESA Competition Commission, as you observed, we had issues where there was some opposition, and what causes that, Andreas, is failure to appreciate the role and the importance and rationale of your mandate. We are not in this business for ourselves. We are not in this business for the CCC. We are simply custodians. We are in the business of ensuring that markets are contestable and players grow to the benefit of the common market. So in that time, we start bickering on jurisdiction, on who should do what, who should do. Implicitly, what we are doing is actually we are negating the very same objective for which we were created. That's what it means. So I told my colleagues that let's go beyond looking at Willard Mwemba or another personality. We go beyond that. We need to go towards the understanding of what is our role and how do we achieve that. And if we think by fighting we'll be achieving our role, then let's go ahead and see if we achieve that. So the first thing is to appreciate and be very honest with ourselves and tell ourselves that our mandate is to protect the process of competition. And once that is done, the next thing would be how do we then make sure that we have a framework that supports that narrative. Okay, so in my view, the first thing is then to what the CCC has done very well, actually, to make sure that we raise awareness. And once that awareness is raised, what are we talking about in there? We are talking exactly about what the CCC has done now. We went to all the countries and said, look, we have not come here to make the situation worse. We have come here to make the situation better by simply filling in the gaps. Okay, and it should be the same here. COMESA may do its own good job at the COMESA level. It's only 21 countries, but there are other countries. Okay, and there are even overlaps there. So what we need to tell our colleagues in Africa is that we have come here to fill in that gap. What happens when there's that overlap? And once we have that honest and straightforward talk on how we fill in that gap, it becomes easier. Then finally, which probably takes much, much longer, is also to start making attempts to review our laws. How do we start making attempts to review our laws? Advocacy to our superiors who are the governments of member states. We did that in COMESA. A number of countries have changed their laws or at least put provisions that expressly recognize the mandate of the Commission. For example, Eswatini, Kenya itself, Mauritius now, Zambia is doing that. Djibouti, we are doing that. We managed to convince the governments of member states on the importance of that, which importance can only be realized ultimately with some legal framework changes. And that happened. I don't see why, if 5 blocks or 6 RECs in Africa join forces together, show the importance, explain this is the gap we are trying to fill in, we are not fighting. I don't see why that cannot happen. And that is my dream, and I hope it can be realized.
I like it. Consensus will rule the day. Let's hope that dream does come true. Thank you, Willard.
We hope so. Thank you so much, Andreas.
Thank you both to Andreas and Willard for those questions and that very insightful answer. Thank you, Dr. Mwemba. That certainly sounds promising, and we're excited to see both how the Commission develops itself and how its relationship with the other RECs, as you mentioned, will play out. So this marks the end of today's African Antitrust Snapshot. Unfortunately, I think it's been a very insightful conversation. Thank you also to Tyla and Andreas for co-hosting the webinar with me. And Dr. Mwemba, you've been very generous with your time and your insights. As always, we continue to look forward to working with the CCC in the near future. And then after we've uploaded this podcast, we'll remain available for people that want to email us or send us messages with questions. And we'll see you all on the next African Antitrust Snapshot.
Thank you so much, Nicola. Thank you. I think it has been a very progressive conversation, and I hope we will not find ourselves on the saying, if horses were wishes. That's That's how the saying goes, right? We believe some of the things I've said here, of course, some are already happening, but even the dreams I have would want them to be achieved. Thank you so much, and you do have a lovely rest of the day.
Thank you very much. Likewise.
Thank you.
Bye.
Bye-bye.
Bye.